Hi, everyone. Good afternoon, and thanks for spending your lunch hour with me. My name is Kendra Bowen, and I'm an estate planning attorney with the Housing and Economic Rights Advocates. And I'm joined today here with another attorney from our office, Irene Zhu. She is also an estate planning attorney with HERA. HERA started the estate planning department because the attorneys there were doing a very good job saving people's homes from foreclosure, helping them with loan modifications, but they were running into problems if, let's say, their clients lost capacity and did not have a durable power of attorney. Oftentimes, when a client passed away, if there was not a trust in place and a home was in the estate, the family would need to go through a probate process. It would be expensive. Perhaps a caregiver child who was living in the home would no longer be able to live in that home. So they were running across those problems. So hence it made sense, because we deal with homeowners primarily, to create an estate planning department there. Today we're going to be going over the basics of estate planning. I call it Estate Planning 101. And we'll start the slides. Irene's going to be running the slides for me today. All right, so we're going to be discussing, great, Irene, thank you. And next slide. Oh, there we go. The what, who, when, why, and where of estate planning. And you'll notice that as I'm speaking, we're talking about two different groups of documents, two buckets of issues here. Some documents will cover what happens when we're incapacitated, even if it's just a temporary incapacitation. And then we're going to discuss the group of documents and scenarios, what happens when people pass away and how are those assets distributed, and how can we help our clients make that process as easy as possible for their loved ones down the road. Next slide. So we're going to just start with perhaps a couple of potential misconceptions that people might have as they come into an attorney's office, or as you're dealing with them with different issues. So oftentimes people think, I don't need any estate planning because I don't have anything. I'm not a homeowner. Well, they have themselves and they have their financial matters as they are proceeding through life. So as I just mentioned, some documents deal not with what happens when passing assets at death, but what happens when people are alive yet incapacitated. So the bottom line is everyone needs some form of estate planning. It's just typically a question of what documents are appropriate for the people at hand. Next slide. Some people realize that California does have a mechanism for distributing assets at death. For instance, a single parent, through California law, their estate would go to their 3 children equally if that person was unmarried. While that would happen, if there are no estate planning documents, people can state whatever they wish in their estate planning documents with respect to distribution, choice of executor, choice of successor trustee. So as long as people take the time when they have proper legal capacity to put in notarized witness documents what they would like to have happen down the road, that's what should take place, and people shouldn't worry about that not taking place. Once again, if people have capacity and have done things appropriately, that should be what takes place down the road when people pass on. Next slide. Oftentimes, we find that people think that they have all of their estate planning done because many years ago they created a will. Maybe they were going on a trip and they quickly created a will. Since that time, they've become homeowners. You'll find as we proceed that if an estate is worth over $166,250, even having a will will not avoid probate, because a will is subject to probate if it's dealing with assets over that threshold. So anyway, we want to avoid a family having to deal with the probate process, and just having a will is typically not enough. Also, a will kicks in when people pass away, and we're concerned about people when they're alive, but yet, let's say, incapacitated. So we want to also make sure that they have the documents that are important during life, during an incapacitated state. And next slide. And then the other common thing that we see is parents will think the kids get along well, they understand what's supposed to happen, they understand what I want. If I was in a precarious medical situation, anyway, we find that obviously when parents are sick, children are at their worst. They're not necessarily in a collaborative state. And then when people pass on, they're very vulnerable and sad, and once again, not at their best. So we can't really trust others to do what we have taken the time to say verbally. It's much better to put things down in writing so that things are not ambiguous and that our desires will be one day carried out. It also, frankly, helps keep the peace in the family if people aren't trying to second guess what maybe they heard mom or dad say. And next slide. All right, so estate planning is a process, and it involves not only your property, but your people, your body, your health. It will address future needs, and that's why people need to state what they want to have happen with respect to medical care, a person to pay bills and finish filing taxes in the event of incapacity, and what they want to have happen when they pass on one day. And while a will is oftentimes one of the parts of it, it's not everything. And next slide. So the documents that we'll be discussing today are as set forth here. So the documents in blue are documents that are really important when we're alive or when clients are alive, but let's say we're incapacitated. So a durable financial power of attorney will handle, it will state who we trust to pay our bills, who we trust to finish filing our taxes, file an extension for our taxes if we're incapacitated in March or April and hadn't gotten around to doing that. A durable power of attorney can nominate someone to represent us in litigation. So it's a very important document and deals with the financial issues that might come up during life. A revocable trust is important, mostly for homeowners or for people who are over that threshold that I mentioned earlier. A successor trustee in a trust will manage trust assets, once again, if the settlor trustor was incapacitated. A successor trustee uses those assets for the benefit of the owner, the trustor. And then when they pass away one day, the settlor trustor passes away one day, that document becomes irrevocable, and a successor trustee will distribute according to the terms of a trust. The Advanced Healthcare Directive is a completely different animal, and oftentimes there is a different choice of the appropriate agent in that document, because sometimes people who are good with numbers, good with finances, are not necessarily the best choice to come into a medical setting and assess things, speak with doctors, see an IV. So an agent, as indicated in an Advanced Healthcare Directive, might be a good friend who's a nurse or something like that, does not need to be a family member at all. So those are the documents in blue. They are all important during life. The documents in yellow come into play when people pass away. So that trust, which was previously amendable, revocable by, of course, only the settlor or the trustor, now becomes irrevocable. The successor trustee just needs to do things according to the terms of the trust. And then we have a will as well. A will and a trust distribute property at death. A will nominate an executor in charge of the distribution of assets and final arrangements. A will, if it is dealing with an estate that is over $166,250, would be subject to the probate process, and a trust would not. It's a private family document and would not be filed anywhere. Okay, so we will start, first of all, next slide, please, discussing, this is just dealing with what I just stated. So estate planning deals with post-death planning, of course, who receives our assets and who's in charge of that process, but then it also deals with incapacitation, managing assets and finances during life, and someone to make good healthcare decisions for you if doctors are unable to effectively communicate with you or your client. Okay, and so we're going to start off with the bigger subject of estate planning, which concerns what happens when people pass away. So once again, we want to avoid probate. So if the gross value of a decedent's real and personal property is over $166,250, it will be subject to probate according to the probate code. The court looks at the gross value of assets. So let's say someone owned a home worth $500,000 and there was a loan against it of $400,000. It would be subject to probate because the court really doesn't give credit to the fact that people have loans against the property. They're going to look at the gross value of the estate. That can be a misconception with people because they realize they just, perhaps in that last scenario, only have $100,000 of equity in the property, but unfortunately the asset itself is worth $500,000. So that would be someone who needs to create a trust and put their home into their trust. Okay, next slide. All right, so there are a few different ways to avoid probate. So as I stated earlier, of course, clients can prepare a trust and put assets into the trust. Oftentimes this is appropriate for homeowners, and attorneys will create the trust and prepare a new grant deed, conveying their interest, however it was on their old grant deed, to their trust. They're always encouraged to put new property into the trust as well. So if they sold a current home and purchased a new home, they would need to let the title company know that they have a trust, give them the certificate of trust, and own that next piece of property in the trust. It's meant to grow with people as they go through life and accumulate assets. Likewise, any significant investment account or bank account would be retitled to someone's revocable trust after they sign those documents with the notary. So anytime after they create the trust, they can start to put assets into it. Here in California, we also have a transfer and death deed. So this can be a mechanism where people can indicate beneficiaries on this deed. And as long as there is a living person left as a beneficiary on that deed, that will be a way to avoid probate. For people who perhaps don't have real property, but they just have various accounts, putting a POD, pay on death designee, or a beneficiary on bank accounts, investment accounts, can avoid probate. Once again, as long as there is a living beneficiary on that account when someone passes away, when the owner passes away. We encourage people to revisit their beneficiary and POD designations, because if anything's changed, or let's say their sole beneficiary is an older person, and there's a good chance that that person may predecease the owner of that account, we want to make sure that people have a contingent beneficiary on that account. So please encourage people, and you yourselves should take the time to revisit your beneficiary designations or POD designations on your accounts and make sure that you have a contingent beneficiary down. Assets a total less than $166,250 gross would not be subject to the probate process. Holding property in joint tenancy can be a way to avoid probate as to the death of the first person. So let's say two people own property as joint tenants. It could be a brother and sister, or for a married couple, it might be in that way, or it might be community property with right of survivorship. When the first person passes away, the property goes to the survivor. They have to prepare an affidavit of death, but eventually that person will own 100%. At that point, if no estate planning documents had been created previously, the last person standing needs to create some estate planning documents to make sure that when that person dies, there is a mechanism to distribute property without going through the probate process. Okay, so we don't really like people to just rely on owning property as joint tenancy, because we estate planning attorneys have to be pessimistic and think, hey, if there are consecutive deaths close in time, there might be a probate here. And we just talked about owning property together with a spouse. We just don't want people to rely on that mechanism to avoid probate. With respect to retirement benefits or any life insurance, once again, we would typically indicate beneficiaries there. Life insurance, we can always put a trust down as a beneficiary. With retirement accounts, we can do that as well. We would not change title of a retirement account or typically a life insurance policy to the name of the trust, okay? With retirement accounts, there can be unfavorable tax implications. So a financial advisor usually will not recommend people change ownership of their retirement accounts, retitle their retirement accounts to the trust, because we don't want any adverse tax implications. So here you can see there are a few different ways to avoid probate, and it kind of depends on people's level of what they have and net worth. Okay. All right, next slide. So we'll talk about a revocable trust a bit. So this is a legal document that attorneys create, And the owner, the creator of this document, is going to be the grantor, trustor, settlor. They're the trustee while they're alive and have capacity. They are the beneficiary. Oftentimes people think that by putting assets into this trust as another entity, and this sometimes happens with some of our old school people, that they're somehow giving up control. They might not own the property. They own it. They own it in a different manner. So it is themselves, Sam Smith, trustee of the Sam Smith Living Trust. So they are still the owner and they are free to sell it, spend the money. They are accountable to no one. They do not need to keep an accounting for anyone. It is all their property, and they are free to amend the document with respect to distribution, change its successor trustee. With a trust, we have a will, but we typically have a pour-over will, which kind of grabs things that perhaps were not placed in the trust and assets that do not have beneficiaries and kind of dumps them over into the trust if for some reason an asset was not placed in the trust. And this document is typically called a declaration of trust. So that's the revocable trust. In the trust itself, we will identify family members. We will indicate ourselves as the primary trustee, but indicate a successor trustee and hopefully at least a second choice in case something unforeseen happens to the first choice successor trustee. We will discuss distribution. Could be a specific distribution of a certain sum of money going to a person or a charity, and then a general residual distribution, percentages that handle everything else, and that total should add up to 100%. A successor trustee in a trust can be compensated. So a typical trustee compensation fee would be 1% of whatever they're dealing with, but it can really be whatever the trustor would like. When someone passes away, or if someone becomes incapacitated, the trustor becomes incapacitated, a successor trustee will at that point need to keep track of what he or she is doing with respect to selling assets, paying bills, etc. So that person beyond the settlor, that acting successor trustee, does need to keep track of what he or she is doing. And when someone passes away, that person will need to present the accounting to the residual beneficiaries. And a good trust will have a spendthrift clause in it and a no contest clause too. Okay, so we're going to create the trust and help people put their assets into it. We're not going to put retirement accounts into it. We can always put a trust which is in effect, which is also already notarized, as a beneficiary on, let's say, life insurance or a retirement account. And then with a revocable trust, we're going to typically have a pour-over will that will help funnel things into the trust. And next slide. The benefits from having a trust versus going through probate, either without legal documents or having a will that would be subject to probate, is that a trust, as long as it's been funded appropriately, is not subject to probate. And it's private, it's not filed. A will is typically filed with the probate court. So if people want to keep their affairs as to who is going to obtain what private, a trust is a good mechanism for that. As I said earlier, fees are whatever you would like. There are no statutorily guaranteed fees to the successor trustee or that person's attorney if he or she chooses to have an attorney assist them in the trust administration. And with a will, there is a statutory compensation according to Probate Code 10-800. A successor trustee can handle the trust assets and make an ultimate distribution without court supervision or approval. They are accountable, but it's to the beneficiaries. So there is a check and balance with administering a trust. With a will that is subject to probate, or for someone who had no will and whose family is going through the probate process, the executor completes his or her tasks, but it's subject to court approval. Assets in a will be subject to estate recovery. If that person was receiving benefits, the state can come back against the probate assets. If assets are effectively in a living trust, those assets are not subject to estate recovery. And typically the administration of a living trust just takes a shorter amount of time, involves less energy, involves fewer fees. So it's worthwhile to encourage people to do this while they're with it and have proper legal capacity and have the time, because when it's needed, they won't be here in order to do it. Probate a will just takes longer and it's more expensive, okay? Next slide. So we'll talk a little bit about a will. A will name an executor, the person in charge of making an ultimate distribution and taking care of any final affairs that people have decided upon. And it will contain language that distributes assets. But as indicated, if it's over that threshold amount, it will still need to go through the probate process that we have here in California. Next slide. One thing I will note, if people own assets in other states too, there could be multiple probates that need to take place. So if someone just has a will or doesn't have anything and owns a property here in California and owns a property in Nevada, they will have to go through a probate there and a probate here. So we want to avoid that. And probate, for those of you who don't know, it's the court supervised process of transferring a person's estate to the beneficiaries named in the will. And this is when you have a will. The court validates the will and appoints the executor as the personal representative. If there is no will, distributions made to the according to the state probate code that we have here. And so if someone passed away without a will, the personal representative would be surviving spouse or domestic partner. The next choice, if that person didn't exist, would be children. And if there were multiple kids, there could be competing petitions, and the court would need to decide who's appropriate, and it kind of goes down from there. So once again, we really want people to choose who would be best in their family, friend situation to undertake these duties one day, because you know the dynamics of your family the best. It's hard for a court to really gauge that in a relatively short amount of time. And next slide. And this is just a chart showing basically the same thing. It goes on and on and on. For those of you who don't necessarily trust family members to typically do what you would like, it's even more important to take the time and properly executed legal documents to indicate those that you trust for these various roles. And next slide. So this sets forth some of the things that an executor would need to do when going through the probate process here. So they're going to file a petition for probate, publish a notice of petition to administer the estate, mail the notice to certain people, and then file a bond perhaps. There'll be a hearing date, and then they will prepare the inventory and appraisal and send that to the probate referee for the valuation, which will be filed with the court. They will need to give notice to the known creditors. They'll pay the debts and file the tax returns. Now, a successor trustee will do some of this. Obviously, they're going to pay debts and file tax returns, but they don't need to go through all of this, all of these procedural tasks. The executor will file an accounting and final petition for the final distribution, and they'll mail the notice to the interested people involved. There'll be a hearing date, and the judge will ultimately decide if everything looks good, and then assets will be distributed and there'll be a record of that filed. So there's a lot of administrative things here. Filing fees are expensive. The court has its costs. So if we can avoid this for our folks, we really try to encourage people to complete legal documents to avoid this and make it a little easier on their loved ones down the road. And next slide. All right, so here's a list of statutory fees. So let's say someone owns a home, that's their main asset, it's worth $1 million. And let's say they have a loan against it for $800,000. Well, the fee here that would be paid to an executor would be $23,000, and that same fee would be paid to his or her attorney. So it can add up, especially if there's not a lot of equity. Once again, we just rather put a little bit more money in our clients' pockets down the road, or at least in their families' pockets, and have them avoid this process. And keep in mind that these fees do not include, the probate referee fees, tax prep, filing fees, etc. So it can really add up for people. And next slide. All right, in this same example, let's say the home is worth $1 million and there's only a $300,000 loan against the property. On the trust administration side, we have $700,000. The cost of administration, just some ancillary costs, will be $20,000, let's say. So there's $680,000 which would be distributed to kids or to the people indicated to take under the trust. On the probate side, we have the same fair market value of the estate of $1 million, same figure for the encumbrances. So we once again have a net value of $700,000. We have basic administrative costs of $20,000. And so we have the same balance of $680,000. But here's where the difference lies. We have the statutory fee to the personal representative of $23,000, and then another statutory fee to the attorney helping that person complete all of his or her duties of another $23,000. So, and this once again does not include any extraordinary fees, filing fees, publication fees. So the distributable balance at the end of this process is going to be far less than the trust administration side. So in this example, $634,000 would ultimately be distributed to children, let's say. So there's a big difference. Next slide. All right, so we're going to do a little scenario here. Bear with me. We have a client, Pamela, and she passed away, and she had her house, which was valued at $300,000, which was titled as Pamela, trustee of the Pamela Trust. She had 2 retirement accounts, which totaled $145,000, and Ben was the named beneficiary on both of those retirement accounts. We have a life insurance policy of $70,000, and Pamela took the time to not only name her mother, Stella, as the beneficiary there, but also to name her brother, Leo, as a contingent beneficiary, like mentioned earlier. And then she has a savings and checking account of $2,000, and she placed her boyfriend, Tommy, as a beneficiary on that account. So in this scenario, in Pamela's scenario, do we believe that there would be a probate here or not? Okay, next slide. Yeah, here, Pamela has really done everything correctly in order to avoid probate. Her house was in her trust. She took the time to put a beneficiary on her retirement account with her life insurance policy. She not only named her mother her first choice as a beneficiary there, and we always want people to go with their first choice, but she took the time to place a contingent beneficiary down on that policy. And then with her basic bank accounts, she did put her beneficiary's name down there. So there wouldn't be a probate prompted really from any of this. So let's look at the next example. Here we have Alex, and he has similar assets. He has the house, which is also worth $300,000. It was titled to Alex, an unmarried man. He has 2 retirement accounts worth $145,000, but he never got around to placing beneficiaries on those accounts. There's a life insurance policy available, and he did indicate his elderly father as his first named beneficiary, but he did not name a second younger person as a beneficiary. And unfortunately, his father predeceased him by 2 years. And then he has checking and savings accounts and just put my girlfriend down as a beneficiary there. So do we think there would be a probate in this scenario? And next slide. Correct, Sudie. There's a beneficiary here, and it would be prompted really by everything that he did. So he owns his house in his own name. He didn't have a trust. He has retirement accounts, but he did not put beneficiaries on that. He has a life insurance policy, and while he did go with his first choice with respect to a beneficiary there, he never named a contingent beneficiary, and his beneficiary predeceased him. And then he has a bank account, which is a small amount, but he was very ambiguous with his beneficiary there. So Alex's loved ones will need to go through the probate process that we have here. All right, next slide. So we're going to talk a little bit about the transfer on death deed. And it works for, single family homes. If someone has a fourplex, it would work. If someone has some kind of a larger building with 5 or more units, it won't work. And then it won't work for, some people, let's say in the Central Valley, who have farmland. You cannot state that it goes to, all of my living children or all of my living grandchildren. You have to actually put beneficiaries down by name on this document. And it's signed, dated, and recorded within 60 days of its signing. And it's notarized, of course. So this doesn't necessarily work for some clients' desires with respect to estate planning, because oftentimes people, when it comes to distribution of their estate, let's say a parent has 2 kids, they want everything to go to the 2 kids equally. And if one of their kids predeceases them, they want the 50% share that would have gone to their deceased child to be held in trust or go directly to their grandchildren from that child. If someone uses this deed, if they put the 2 kids down as beneficiaries and that same child predeceased the owner, 100% of the value or 100% of the ownership of this piece of real property would go to the living child. So it oftentimes doesn't meet the desires of people. Now, someone who might just have 1 child, it would work there. Keep in mind, though, when we have to be horrible pessimists, if that child predeceased the owner, let's say passed away, and then 60 days later, the next person, the owner, passed away, there would be a probate, because if there's only 1 beneficiary there and that person predeceases you, there's no named beneficiary. So once again, be a bit leery of using this, but it can work in certain situations. And then here we just have an example of what this looks like. It's a relatively simple document to create. Note that it needs to be notarized and then filed within 60 days, okay? All right, next slide. All right, so now we're going to discuss what happens when we're alive yet incapacitated. How do we help clients deal with this scenario? So I'm going to pass it on to Irene Zhu, and she's going to discuss the durable power of attorney for financial purposes and the advanced healthcare directive.
Thanks, Kendra, for addressing the bulk of our presentation on Estate Planning 101. And I will breeze through this part of the presentation talking about power of attorney and healthcare directive documents that Kendra briefly touched upon earlier. These documents in different from the wills and trusts that Kendra talked about, regardless of how much asset we own or our clients own. We all need these documents in preparation for the likelihood of ourselves becoming incapacitated or our loved ones becoming incapacitated. So these documents, they cover different areas of our lives, but they have some similarities. So I will mostly talk about them as a group. So like I said, power of attorney and healthcare directive, they're both important part of our estate planning. And it's basically us naming an agent and with several backup choices, people that we trust, people who are good with numbers, who are familiar with the healthcare system, like ideally. And usually people name their family members. And so we name an agent to help us take care of financial related matters, things like paying the utility bills and the filing tax returns and accessing bank account balance and things of that nature. And for advanced healthcare directive, there are things regarding, when accidents happen and if we are in the hospital, what's our thought on paying medication and our consent to different procedures, and also there's end of life decisions and matters concerning organ donation, and after we pass away, what are our thoughts on the disposition of remains and things like that. So there are a lot of flexibility when we make these choices. Some people like to be very detailed in listing out what they would like to see happen in the documents, and other people will defer lots of kind of decision making to their agents that they deeply trust. So the main purpose of having these documents in place is so that we can avoid headaches when the unfortunate events happen. And also, if we become incapacitated without such documents in place, there will be the conservatorship court proceedings that need to happen to determine who can the agent be to take care of matters for us. And as you can imagine, that might not reflect our personal wishes. So there are different types of power of attorney. Basically, you can restrict how many different powers you want to give to your agent, and whether it could be a blanket authorization or you list out ones that you think will be most relevant to your case. And for choosing agent in these situations, there are different considerations, and maybe for healthcare advanced healthcare directive, it's wise to choose someone who is in close proximity to yourself, who can answer to a medical emergency, and life circumstances change. These are the conversations that you want to have with your family on an ongoing basis. So I briefly mentioned this. Conservatorship is a court proceeding that will need to happen if we become incapacitated or our loved ones become incapacitated, not able to act on their own behalf. And the court will step in to determine who can the agent be in that situation. And any time when the court is involved, not only it might not reflect your personal wishes, it could also be costly, both in the monetary sense and as well as the time that it takes. So if possible, we want to avoid that. And usually setting up those documents, the power of attorney and healthcare directive, is much less headache than having to go through this court proceeding without those documents in place. So in Advanced Healthcare Directive, California calls this Advanced Healthcare Directive. There are other states that you might have heard, medical POA or living will and all kinds of names. So there are different ways of calling that, and they address the same areas. And then in the medical world, there are other forms and other arrangements that you can make that are not the same as Advanced Healthcare Directive. And they take care of different scenarios. So a post form, if you have seen as a pink slip, usually for the older and people with very serious disease or condition, they would have this arrangement in a pink slip that says what they would see happen in emergency. And it's a quick way for ambulance drivers or the other medical worker to kind of quickly know what this person wants. And then there's the DNR form that people sign in the hospital. So these are different from Advanced Healthcare Directive, but in the Advanced Healthcare Directive, you can make references to these other arrangements made. And this is a quick example of the post form and also DNR that I talked about. So it's a common kind of a way of thinking that Advanced Healthcare Directive is for people who are older, but actually even well, all age group, like nobody really knows what life brings, and you see these news articles about college age kids, being in the hospital for one reason or another, and their parents suddenly cannot access their medical files as they would be able to when the kids are minors. So it's important, no matter what age we are, no matter what situation our clients in, it's important to have these documents set up when we're well and able, and life is going well, so that we can be prepared when the unfortunate circumstances hit us. So we talked about all these documents that occurred earlier in the presentation so far. So the blue ones on the left are ones that are significant during our lifetime. And then after we pass, then the trust that was once revocable becomes irrevocable, and the will becomes final, the last version that we execute, and the power of attorney and advanced healthcare directive will no longer be valid. So I will invite Kendra to come back and help us wrap up the presentation. And just a quick reminder, if you have questions, I've seen some folks dropping questions in the chat. Thank you for doing so. If you have questions and haven't had a chance to write it down, it's a good time to do that now, and we will address them in the end. Thank you.
Thank you so much, Irene. Let's go over what's going to typically happen when beginning with a client with the estate planning process. So you always want to ideally meet with someone in person. Nowadays, it's not all that practical. So at least through a Zoom meeting to kind of, get a sense that they have capacity. If it's a married couple, it's a good idea to meet with both spouses, because sometimes one person wants to do estate planning and then the other spouse does not want to. So we don't want to waste anyone's time. So it's a good idea to make sure that both parties are on board with the process. And frankly, at that point, the parties don't have to have agreement as to their decisions yet, but they just should want to proceed with the process. The clients will provide some personal family information, ages, legal names of children. They certainly don't need to provide social security numbers for the children, and don't need to provide their own social security numbers, because down the road, when they do, let's say, put a bank account into the trust, they can use their social security numbers as the trust ID number, but that does not need to be typed into the documents, and I would advise against that. They should also give you a sense of their finances. So where are they? How many homes do they have? About how much do they, have in investment accounts or retirement, that kind of thing, so that you know how to advise them with respect to funding the trust down the road, if that's the process that they're going to do. At whatever point they have given you information about the decisions they would like to make as to their choice of agents in the durable power of attorney for financial purposes, healthcare directive, an executor for a pour over will or a regular will, and then for the decisions that will be stated in trust documents, you will be using that information to prepare drafts for them. Ideally, at this time, you would also have been provided or have obtained yourself a copy of the grant deed if they are a homeowner. When they come back to sign documents after they approve the draft and you are reviewing documents and they're signing the documents, ideally they are signing their new grant deed if they're a homeowner, conveying their interest, however it was in the prior deed, to their trust. That way, everything's signed one day, and once they leave the office, you can go ahead and file that new grant deed with the county recorder's office, so that there it will reflect the fact that they still own the home, but they own the home as trustee of their trust, or an individual would do so in an individual trust. The day that they're signed, once again, they are effective, and we attorneys can help clients fund their trust with their real property by preparing that grant deed and mailing it in for them. With respect to funding the trust with the financial assets, if clients have a financial advisor, sometimes you can just provide an abbreviated version of the trust to that financial advisor, and they will take care of retitling accounts that they're helping them with to the trust. If someone doesn't have a financial advisor, just let's say has a bank account or an investment account on their own, once again, you want to encourage them to fund the non-retirement accounts to the trust. It's a little bit of retitling work that they need to do. The good news is that once they have the trust, if they obtain something new, they can open up a new account in the name of the trust. And then we also encourage people, while we congratulate them when they finally finish their estate planning, we want them to revisit their documents every 3 years or so. Something may have changed in their life or within the dynamics of a family, which would cause them to make different choices in their documents. We always want to make sure that the documents are current and reflecting what our clients want to have happen down the road. If they need to be changed, clients are free to do that as long as they have capacity. So you're catching that window when they can change their documents and change their choices to reflect what works for them with respect to financial and healthcare issues. Okay. We can, here is an example of some people who did not complete their estate planning process or did not go back and revisit their documents and make changes as needed. So Heath Ledger had apparently completed estate planning documents, but never changed them when he had a child, and there was a lot of litigation and confusion there. Barry White, while he was married, he had been legally separated for a very long time, and he had a longtime partner. He didn't change his old documents, and once again, there was a lot of litigation. So this goes to encouraging people to pull out that binder and review their choices every 3 years or so. Okay, any questions? I have seen a couple of questions. I'll address one that I saw earlier. Someone asked if a pour over will prompts a probate. So a pour over will would be the will that accompanies a trust, and it just kind of grabs assets and places them in the trust. It doesn't avoid probate, but it makes sure that they are one day distributed according to the terms of the trust. So at least by having a pour over will, clients are assured that if they forget to put something in their trust, at least those assets would ultimately be distributed according to the terms of their trust. So if it's handling something over $166,250, that asset would be subject to probate, and the people would have to go through the probate process. So just having the will doesn't prompt a probate, but it's what that will applies to. And let's see, I'm going to check some. Yeah, with minors, when dealing with minors with accounts where there are beneficiaries, that's a good reason to encourage people to think about creating a trust, because in a trust, we will have some language in there that deals with minors. So instead of minors obtaining assets, let's say at 18, we typically state that until, let's say, age 25, those assets would be used by the successor trustee for the health, education, maintenance, support of the minors until a certain age, perhaps until age 25. So likewise, on beneficiaries for life insurance or other assets, you can put a trust down as a beneficiary there, and that way you know that a minor is not going to have access to those funds at age 18. And also, I will state, trusts and wills can indicate guardians for minors too. Either vehicle can be used to indicate guardianship choices for dependent adults or minor children. Another question, it's about retirement accounts. There can be adverse tax implications. I think it's a penalty of 10% if you change the ownership of a retirement account. So don't change ownership of your retirement account to the trust, but once again, you can certainly put the trust down once it's signed and executed, of course, with the notary, as a beneficiary on a retirement account, and the money will flow through there. Okay. A question about people on fixed income and how do you do their estate planning at little cost? Okay, well, a good recommendation for a nonprofit doing work in Alameda County would be us, HERA. We do estate planning, and we do, we're based in Oakland, but we do estate planning for folks, frankly, around the state. So someone who wants comprehensive estate planning can certainly call our intake line, which is indicated on the slide, and make an appointment with one of our intake people, and they will hopefully set them up to speak with one of us after getting some preliminary information. Now, for people who just maybe need a healthcare directive, and power of attorney. If they are with Kaiser, or I think Sutter has a pretty good one, they can go online and download that medical facilities healthcare directive and just complete it. And they even have spaces where people can write in very specific healthcare wishes. So that can be a free way for people to complete a healthcare directive. The main thing is to sign it in front of a notary or have it witnessed by two disinterested people, two people who are not mentioned in that healthcare directive, and thereafter give it back to their healthcare provider and have them scan it into their system, because it needs to be where people can find it and use it one day. So people can complete a healthcare directive on their own and put their agents down on that document. They can also pull down just like a kind of a California statutory power of attorney document. It's brief, but people can delete powers that they would not want an agent to have. If they want it to be broad, they can go with what's there, and they can indicate a first agent to act as an agent for financial matters one day, and then put a second choice down as well. So for people who maybe just need those two documents, there are some free ways to do it. And once again, the power of attorney needs to be signed in front of a notary. The client can't just sign it on his own and put it in a drawer. It needs to be notarized and perhaps given to the next person named, so that once again, if that client becomes incapacitated, the person who would need to do things on behalf of the client would have access to it. And once again, that choice, that person is always a fiduciary to the client. So, they're accountable for what they're doing. Qualifications for clients to utilize our nonprofit estate planning services. So we do charge for our services, but the fees are on a sliding scale. So if a client makes, let's say, under, I think, $24,000 a year, they are going to obtain estate planning legal documents for free if they are a homeowner to create the new grant deed reflecting that they are choosing to convey ownership of their property to themselves as trustee of their trust, and to do the preliminary change of ownership report, the document that accompanies that deed. We charge $170 to prepare the deed and PCOR. Other than that, someone under that level will probably get the estate planning documents for free. We have many clients who are over that level, and their fees are on a sliding scale. They're typically quite a bit less than private practice, but when we do have clients who, let's say, make a couple $100,000 a year and come to us and want us to do estate planning documents, the fees are kind of close to private practice. So again, those people are kind of helping to subsidize the folks that are obtaining these documents and services. One thing to note is that when we do provide estate planning legal services and we are figuring out the fees, we do ask for proof of income too. So people redact their social security numbers, and then we, calculate the fee based on proof of income. Yeah, a question about why financial institutions ask for security numbers when entering beneficiaries. On their paperwork, they do, sometimes people can have the same name. So I think they just want to have a very clear identifying number for that. And it's on their paperwork, you hope that it's all very, very safe. Once again, on any estate planning documents that you're preparing, you do not need to put social security numbers of the trustor. And I advise against doing so, because if you have a couple of accounts, or the client has a couple of accounts and he's giving the certificate of trust to a bank, he just doesn't need to be walking around with his secure social security number reflected on those documents. But changing an account to the trust or opening up a new account in the name of the trust, of course, the trustor will need to give a social security number to, let's say, a bank if he or she is opening up a new account and it is in the name of the trust. Cost of a living trust with wills and a trust. Again, it really depends on income, so it's hard to say. It can be anywhere from $0 to $2,700 for really high income people. Yeah, so I can't really let you know what the cost is of a trust and a couple of pour-over wills. a question about whether or not we handle probate cases. We do not have the bandwidth for those at all, so we don't handle probate cases. If it's someone who's relatively low income, they can call the state bar and try to find a probate attorney who will charge on a sliding scale, perhaps, or even do something pro bono. I think that's a good way to start. Thank you. Take care, everyone.